Hey, this is John. Let's Talk Native is now on Patreon. You can support the show by going to patreon.com/Let's Talk Native. We will be producing exclusive content for our Patreon supporters. Thanks for checking us out.
Let's Talk Native is produced at the LTN Studios on the Cattaraugus territory of the Seneca Nation. We break all the rules for Native media by peeling back the layers of assimilation and indoctrination. No prayers, no buffalo speeches, and no spirituality shows. While this podcast does not provide a path to spiritual enlightenment, we do take a tough look at history, oppression, and our survival. We highlight the voices of Native activists, writers, poets, artists, thinkers, and musicians who are fighting for the rights of Indigenous people all over Turtle Island. We may step on a few toes through our examination of culture, art, politics, history, and identity. But the real goal here is to bring our people together by breaking down what separates us. In this moment of historical change and social justice, our voices matter now more than ever before. So, welcome to Let's Talk Native with John Kane.
Hello and welcome to Let's Talk Native. Got an interesting show for you today. It's probably not a big surprise that I'm going to talk about Ruth Bader Ginsburg. I'm sure that what I'm going to say about her is different than what you've heard elsewhere. I will say right off the bat, I do have a video that's on our YouTube channel, which is Let's Talk Native TV, and the title of it's Legally Invalid, and it discusses Ruth Bader Ginsburg's not just her ruling, but the opinion that she wrote in the City of Sherrill versus Oneida back in 2005, where she specifically cites the Doctrine of Christian Discovery as footnote number 1, which contributed to her decision, and not just her vote, but her decision and what she wrote in terms of her opinion on the subject. Now, I bring that up and I bring her up because there's a lot of people who are just, praising her life. And look, sorry, sorry she died. I mean, it was kind of expected. She was in her 80s. She's been struggling with cancer for a number of years. It's not like a big surprise. There's a lot more politics associated with it than as far as what her replacement is going to be, who's going to replace her, and that kind of stuff. But in the midst of all this is just an outpouring, and of course there was also I think there was a TV special or something like that. I didn't really pay that much attention to it, but over the last year, and she's become a bit of a rock star for the left. I mean, they start referring to her not just as RBG, but the notorious RBG, and she's earned a lot of praise for her role on the U.S. Supreme Court. Now, some of that praise, I mean, when she's praised as somehow this great dissenter, somebody who pioneered the direction of the court and that kind of stuff, she almost prided herself not only in her ruling with the majority in the vast majority of cases that she ever got to rule on, but the fact that the court itself is overwhelmingly unanimous or near unanimous in most of its rulings. And of course, they always highlight, because of the right versus left, the decisions that are 5-4 one way or the other. So that's always the issues that get discussed. But I'll tell you, a lot of her rulings, she was rarely the deciding vote. And in many of her rulings, she ruled with the rest of the court without being some great dissenter. Look, I know she's oftentimes praised for the role that she played in perhaps swaying the court on women's issues and even some LGTB 2S cases and that kind of stuff. But I gotta say, if you're a woman on a court, and through most of her tenure on the Supreme Court, there was only 2 women. If you're only one of 2 women on the Supreme Court, it's not a big leap to be one of the voices of reason on women's issues. That's not, that's not very sensational to me. I mean, I would expect the women on a court to make sure that these courts don't get away with the chauvinism that they would have gotten away with had there been no women on the court. The real challenge for me is when somebody of a specific ethnicity, skin color, if you want to go there, religious belief, can apply a certain level of justice to people who are not of their grouping as a people. So when I hear somebody like Ruth Bader Ginsburg, who is Jewish, from New York City, from I think from Brooklyn, I guess, and who is touted as a civil rights champion, then I hear some things that she's done that certainly would challenge that. So the question that I also have is, so how do you judge somebody? Do you judge them by the good that they've done in their lives, or do you judge them by the bad things they've done in their lives? And we get into this question of, well, if somebody made a mistake or did something terrible, can they right it? Or are they redeemable, so to speak? I mean, look, if somebody commits a rape or a murder, you don't balance that against all the good that they've done. And I'm not suggesting that Ruth Bader Ginsburg raped or murdered anybody. But there's a couple of rulings, and this City of Sherrill versus Oneida Indian Nation case is certainly one of those cases that I think is very, very problematic. And she never righted the ruling. I mean, it's not, and she wrote the opinion on it, which to me, the opinion is even sometimes worse than the ruling. Look, Native people, we're used to having cases ruled against us. But when the opinions are written, all of those words in the opinion, they become legal dicta that are used over and over and over again in this idea of establishing precedents in these rulings. And that's how a ruling that might be narrow can be used more broadly because of all the stuff that's written in the opinion. And so, the ruling is one thing, but the written opinion becomes actually has a bit of a life of its own. So when I think about Ruth Bader Ginsburg in her ruling, and I'll get into explaining what the City of Sherrill versus Oneida was in just a second here. But when I think of how egregious that ruling was, I'm sorry, I can't give her a pass because she did other good stuff. I mean, ruling properly and really ruling in to advance justice, that should not seem like the exceptional thing. That should be the default. We should expect people to do that on the court, regardless of who appointed them. I mean, the expectation is that, yes, the court will rule properly based on not just, well, of course, they'd have to rule not on justice, but on law, which aren't necessarily the same thing, obviously. I've talked about that before. So when you see a bunch of rulings that seem, oh yeah, those are really positive things, and she wrote a really good opinion. Okay, but was there anything that was striking in the opinion that really changed something dramatically, or was the time just right for a change? Because when I see some rulings that she's made, and the City of Sherrill versus Oneida is one of them, there was an opportunity there. There was an opportunity to to right what had been established wrongs. And at the end, she defaulted to all of the standard white supremacy, racist legal doctrines to rule against the Oneidas. And it's problematic. So, again, this is a woman who oftentimes gets associated with being this great dissenter, when that's not really necessarily the case. But let me talk about the City of Sherrill versus Oneida. In this case, the Oneida Nation was purchasing land within an area that the Supreme Court had ruled they had the right to sue for fair title to. And this ruling was back in the 70s, but there had never been a settlement on the Oneida land claim. It would never got worked out between the states, between the state or the counties and the Oneida Nation. It was just got mired with, some factionalism on the side of the Oneidas, with the Oneida tribe of Wisconsin, the Oneidas in Wisconsin, the Oneidas in Ontario, and the Oneidas in New York, not necessarily seeing eye to eye, and who should take lead on some of these negotiations, but nothing ever got settled there. So the Oneidas in New York, they at some point decided they're just gonna acquire lands within their ancestral area, within that area that the Supreme Court basically ruled that they had a legal claim to. And although the Supreme Court wasn't giving them the land, they're just saying they had a legal claim to. So they were, and among this land was the land that they built their multi-million-dollar casino on, Turning Stone. But in the city of Sherrill, the Oneidas had bought some lands, and they were operating a couple of gas stations, cigarette stores, and they were no longer paying taxes on that land because they are saying we are reclaiming the land. We're not just purchasing it. They purchased it on the open market, but they're not just holding it as a property under a village or county or state deed. That they were reclaiming it as Oneida land. So this goes all the way up to the Supreme Court, and the Supreme Court essentially, it played out in the lower courts before it gets to the Supreme Court, and the Oneidas lost, and then they won, and then it gets all the way up to the Supreme Court, and different things were taken into consideration at different levels in this in this legal battle. By the time it gets up to the Supreme Court, Ruth Bader Ginsburg not only rules against the Oneidas, but she overturns, key aspects of some of the lower court's rulings. There are three legal doctrines that are at play in this case. One is called laches, which is essentially how much time has transpired since this land was being reclaimed. Can you make an argument for land claims after a certain amount of time has transpired? So that's this doctrine of laches. The other one is the doctrine of acquiescence, which is close to laches, but what it means is if you remain silent for too long, then whatever is a long acquiescence is conclusive of the latter's title and rightful authority. So if there is a dispute between two entities, and this might be between states, but it's not necessarily just to native land claims. But if there are two conflicting views on the land title or the authority over land, if so much time has passed, then whoever has maintained that authority for that longer period of time, that acquiescence, all that time that transpired that where nothing was ever brought up, is conclusive enough authority for the one who's maintained control over it last, so to speak. So that's the acquiescence doctrine. And then the doctrine of impossibility. And I like this one. Just because the whole idea of saying that we have a doctrine of impossibility, like if something is impossible, then we can't acknowledge it. Well, what they're calling impossible is the idea that native people could reclaim land, period. And if it's land that a township or a county or the state has maintained or has taken over, however they got it. I mean, because the doctrine of impossibility does not consider whether it's the land was acquired legally or not. They're saying, but if they've had it for a long enough period of time and of a certain jurisdiction, there's a doctrine of impossibility that we can employ that says it is impossible to return land that has been surrendered to another jurisdiction, by hook or by crook, to return that back to its original jurisdiction. They said it's impossible. Now, the latter, that last one, the doctrine of impossibility, what is so wrong about that one is that 200 miles down the road from Oneida is Seneca territory, and Seneca's had a a dispute with the city of Salamanca over a lease, and it was settled not in a court, but it was settled by an act of Congress called the Salamanca Lease Settlement Act. And in that, the Congress provided a mechanism for the Senecas to reacquire lost land. Not feed a trust application, not going through the Bureau of Indian Affairs necessarily, but just a one paragraph addition to the settlement agreement that said that they could a 30-day process. They could just announce that they're requiring this land, and the Interior Department and others could comment. They had 30 days to determine why this land should not fall under a specific provision called the Non-Intercourse Act, which means it becomes native land. And it's just a 30-day process. So they had in place, through an act of Congress, a very specific streamlined process for the Seneca Nation to reacquire lands that another jurisdiction had taken control of, and that they were returning back under their own jurisdiction, which completely defies Ruth Bader Ginsburg's use of this impossibility doctrine that she was citing from some place out west, where the land was checkerboarded and all this other stuff. A completely different scenario than what the Oneidas were reacquiring in terms of purchasing off the free market, which is what the act of Congress associated with the Seneca Nation was enabling Senecas to do: buy the land and then and just take it off the tax rolls, basically, and assert it as Seneca title, not as state title, and not held in trust by the federal government. None of that stuff. So her ruling was just wrong there, and you gotta believe that some of the basis for that being so wrong was her bias and that bias towards racism. And one of the reasons that it's easy to come to that conclusion is, and I'll get into a little bit more on the laches and acquiescence, but when she cites in footnote number 1 the doctrine of Christian discovery, that is problematic. For one thing, she's Jewish, and she's citing a doctrine of discovery which is basically born out of papal bulls from the Vatican in the 15th century, late 15th century and early 16th century, as basically saying that Native people. In fact, I'll read what she quoted as the when she talks about the doctrine of discovery. She's under the doctrine of discovery, and this is from footnote number 1 in City of Sherrill versus Oneida, written by Ruth Bader Ginsburg. She lists this as footnote number 1. Under the doctrine of discovery, fee title to lands occupied by Indians when the colonists arrived became vested in the sovereign. First, the discovering European nation, and later the original states and the United States. So in other words, Native people weren't sovereign. And the way she writes it, she said it became vested in the sovereign, meaning the colonists, meaning the crown that had just only because they discovered, not because they had somehow won title, purchase title, to the out of spoils of war or anything like that. But once the colonists arrived, the title became theirs just by arriving, and she doesn't say how. Just simply by virtue of arriving, and that it first became, the European discovering European nations, and then the states and the United States. That is not only a racist dogma, a racist doctrine. It is actually called that in the UN Declaration of the Rights of Indigenous Peoples. That's why I call the video on Ruth Bader Ginsburg legally invalid, because that's exactly what the UN Declaration of the Rights of Indigenous Peoples calls this kind of legal doctrine and practice. They said it's legally invalid. But this is what Ruth Bader Ginsburg used as part of her foundational belief. So when I hear people talk about her advancing civil rights, I'm sorry, if you're harboring something as racist as the doctrine of Christian discovery, and again, ironically, she's not even Christian, But a church dogma that becomes somewhat codified into law, the idea that she could actually do that shows not just a bias, and not just a bias towards law, but a bias towards some of the very ideologies that lie at the foundation of white supremacy. This idea that the church is infallible, and that they could make these kinds of rulings. All right, let me talk a little bit about the latches and acquiescence. Now, I explained what they were, but here's the thing: when anytime somebody says, "Well, too much time elapsed," and you're silent, and you were silent for too long, the Oneidas couldn't even have their day in court until the 1970s. I mean, this, she refers to from 1805 when this somehow the title to this land was taken over by the city of Sherrill or New York State or whatever. She says, from 1805 to present day, the delay in seeking equitable relief evoke the doctrines of latches, acquiescence, and impossibility. So that's where she says all three of those legal principles apply because too much time elapsed since 1805. Well, like I said, the problem is the Oneidas couldn't even get their day in court until the 1970s. So to suggest that they were somehow silent since 1805, just because you didn't hear the voices doesn't mean they were silent. And the fact that they had to submit test cases just to overcome the legal hurdles to get into federal court. And of course there were other policies that were generated that were supposed to resolve some of the illegal land seizures by the states and the counties, and none of them were equitable. I mean, one of the things that she also cites in this thing is that the very problems that are caused by jurisdictional issues on lands that are attempted to be reclaimed by Native people is the very reason that Congress put together this deed of trust process, but where a Native territory or Native people could apply to the Interior Department to have lands taken into trust for them by the federal government. Of course, that's a whole nother problem. The fact is that the deed of trust application is very limited on who can use it. If you can't clearly demonstrate that you are under U.S. jurisdiction, not at the time of the application, but back in 1834, I mean, I'm sorry, 1934, you can't even apply for this thing. And of course, you don't actually own the land. You're actually acquiring lands by whatever means, but then you're asking the federal government to hold the title for you, which is kind of a problem for Haudenosaunee, because we have not necessarily submitted to that notion that our lands should be held in trust for us by the federal government. And although that might be common practice in some parts of the United States and Canada, that's not something that we've necessarily agreed with. So, I mean, when somebody says, "Well, there's another way to solve your problem," yeah, but the hoops that you want us to jump through to solve that problem do not necessarily result in what we're really after here. So, I'm very, very troubled by Ruth Bader Ginsburg's ruling in the city of Sherrill versus Oneida. Not only and again, I want to reiterate that the Oneidas purchased this land. They didn't. They weren't trying to have this land awarded to them by a court. They'd already bought the property, and this was Ruth Bader Ginsburg saying, "No, you can't do that. You can buy it, but you have to own it as Americans do. You have to own it in a state deed, and you cannot claim jurisdiction over that land." She goes on to say how difficult it would be if the Oneidas were purchasing parcels and created a checkerboard of varying jurisdictions. And the crazy part about that is that's exactly how lands were taken from Native people in the first place, parcel by parcel, and then this idea that they would enforce overarching jurisdiction over lands whether they were held by Native people or not. So what she's saying is difficult. It was only difficult if we created the checkerboards by reacquiring lost land, not if the states or private land purchasers created the checkerboard by swindling, leasing, whatever lands from Native people. It is, again, to me, you cannot ignore the racism associated with this ruling, and you can't give her a pass on this. And the reason I come back to the fact that she never righted this wrong. She never corrected it. So when people talk about redemption, when people talk about, you have to take her whole life in its entirety and keep a scorecard. If you've never removed and if you've never done anything to restore the injustice that you created with a ruling, then I'm sorry, you just can't ignore a bad ruling and say, well, that bad ruling is outnumbered by the number of good rulings. This was the opportunity, and again, I got to also have to say this. This was only 8 justices ruled on this. This was a 7-1 ruling, so it was nearly unanimous. She was not the dissenter in any way, shape, or form, and again, her putting the doctrine of Christian discovery into the legal record, even as only a footnote, again, it damages the credibility of the court. It establishes a racist doctrine as part of a foundational legal principle, and of course these other doctrines, laches, acquiescence, and impossibility, they're weak at best. It wouldn't have taken a legal genius to figure out a way around this. Certainly, the doctrine of impossibility could have been negated simply by the Salamanca Lease Settlement Act and the Land Acquisitions Clause. That was a no-brainer. Shame on the lawyers for the Oneidas for not being more proactive as it relates to that. But you're the judge, and you're citing some of these other cases, and you're supposed to be in the making these rulings in the interest of justice and the constitutionality of the law that is being applied. And this was not a difficult case to rule on. I mean, other issues could have been raised, but at its core, this notion that to suggest that in 2005 you were going to affirm legal doctrine that had already, that were sometimes 50 or 100 years old, to say, no, Native people can't reclaim land. It just, I mean, especially when you consider, again, she's Jewish, and this longstanding debate and battle between Israel and Palestine. I don't know how somebody who is of an oppressed group of people in the way that Jewish people and Israelis in particular hold themselves, could not have considered this differently. So, and that's just one example. We're gonna we'll take a break here in a little bit, but and when we come back, there's a couple of other cases that and some other statements I think that are worth noting. And again, I want to reiterate that this isn't about trying to demonize Ruth Bader Ginsburg. This is about trying to give some balance. For all those people who think that Ruth Bader Ginsburg was this champion of human rights, that's not necessarily the case. And, I think you have to consider the rulings that she did make within the context of who she was as an individual. And I think that's why I think considering her Jewish faith and her her background in looking at another oppressed people like Native people is reasonable. But also, if she's made rulings that favored women in the workplace in particular, when she's had to go through her own personal challenges, whether it's within the being a lawyer. I mean, she couldn't get hired by a law firm. She, after, in spite of her grades and all this other stuff, the barrier, the glass ceiling, was because she was a woman. So when she fights for those women's rights, it's a very personal thing. And there's, I'm not saying it's a conflict of interest, but quite to the contrary. She is advancing something that has a personal that she has a personal stake in. So anyway, look, we'll take a break here when we come back. I do want to talk about the Asian American band that fought to copyright their name, the Slants, and how that affected the copyright protection for the Washington football team's name, and Ruth Bader Ginsburg's ruling in that case as well. We'll do that when we come back. This is John Kane. This is Let's Talk Native. All right. Hey, thanks for coming back. This is John Kane. This is Let's Talk Native. Hey, I want to give a shout out to the folks listening on WPFW in Washington, D.C. We are talking about Ruth Bader Ginsburg, and we're probably offering a perspective you may not have heard before. And some of you may be aware that she made this ruling in the city of Sherrill versus the Oneida Indian Nation of New York in a manner that for many of you, but you think it's probably inconsistent. I mean, when I'm talking to some of the liberal folks in New York City, and when I'm doing some of my live events, and I say, well, Ruth Bader Ginsburg isn't exactly a hero to us. I mean, people are appalled. They can't believe it. They can't believe that, this liberal darling, this darling of the left on the Supreme Court, who's been there for so long, had bad rulings, and she certainly did. And like I said, for the most part, she ruled with the majority most of the time. In fact, she went on record saying that the overwhelming majority of rulings at the Supreme Court, the court that she's been a part of, for so long, most of the time they rule together, if not unanimous, near unanimously. And so the split court, the 5-4 rulings, they are the exception to the rule. One of the cases that unanimous cases that she ruled on was a case. I can't remember. Lamb was one of the parties of the case, but it's a case called the referred to as the Slants case, and this was an Asian band that Asian American band that wanted to copyright the name Slants for the name of their band, and they were denied that application through the Patent and Trademark Office. And the reason they were denied is because there was a law passed called the Lanham Act that prohibited the issuance of copyrights for derogatory terms. Metal v. Tam was the name was the case, if you want to look it up. But if you just look up the Slants case, you'll find it as well. Now, the word slants is a derogatory word that was used. It was a racial slur being used generally for Asian people. But this band wanted to reclaim that name, not unlike many black performers try to have reclaimed the N-word in their lyrics or in song titles and that kind of thing. So they figured if they could take the name back, that they would they would take ownership of it, kind of deal. So they were fighting the Patent and Trademark Office for the right to trademark this name. Now, the implication was at the same time that the Patent and Trademark Office was ruling against this Asian band, TAM, they were also made some rulings against the Washington football team for their use of the R word as a racial slur for their name. So, in a way, the Washington football team was smart in delaying their litigation over this, and instead let a party enter into this debate over the Patent and Trademark Office that was of the ethnic group that was using a slur and wanted to take ownership of a racial slur, rather than, in the case of the Washington football team, a team that has no affiliation with being Native, but wants to use a racial slur for Native people as their name. They sat back and let this thing play out with the band Slants fighting for their right to do the name. Now, there was no question that the Supreme Court knew the ramifications of this, and they knew that while in the case of the Slants, it was an Asian group of Americans that wanted to reclaim a racial slur, so they weren't insulting somebody else. Basically, they were trying to reclaim this racial slur for their name, which is different than a white group claiming the N-word, or a white owned football team claiming the racial slur for Native people. But they ruled unanimously in favor of this, knowing that they were undoing some of the battle that Suzanne Harjo and Amanda Blackhorse and others had been successful in fighting the Washington football team. So again, was this a proper ruling? I don't know. I mean, here's the thing. The reason that the Lanham Act came out in the first place was because it's not that somebody can't call themselves the R word or the N word nobody's prohibiting the speech, but the idea that a government should provide a legal protection for somebody to make money to commercialize a word, there should be some limitations on whether a government can protect somebody's use of a racial slur. That's what the Lanham Act was all about. This ruling relating to the Slants totally undermined that, and obviously created a certain vindication for Dan Snyder and the Washington football team as well. It may be a bit of a moot point since pressures came upon the Washington football team to change his name. Frankly, I can't honestly tell you how well the Slants are doing with their copywritten name, But again, there's a ruling that clearly was an anti-Native ruling. I would, venture to suggest. But so there you have that as well. Now the other thing that I want to talk about also is, look, people also were proud to say that Ruth Bader Ginsburg didn't avoid controversy, which isn't true. She made her rulings whether they were controversial or not, but when she wrote a book and was doing her book tour, media tour, she was interviewed by, I think, Katie Couric, and she was asked about Colin Kaepernick. I think this was back in 2006, and of course, what she was asking was about Colin Kaepernick's taking a knee during the national anthem, and Ruth Bader Ginsburg, in pure white fashion, said it was stupid. It was dumb. She said that Kaepernick's protest was dumb and disrespectful. And she compared kneeling during the national anthem, with all of the explanation as to why he was doing it, she compared it to flag burning. And she said, I wouldn't lock anybody up for it. But she basically said it was ridiculous to do such an act. Now, look, to not agree with it is one thing, but when you minimize the actions, especially of marginalized people, in this case, a black person who's trying to raise awareness to an injustice, and you call that means for raising that awareness dumb, disrespectful, or ridiculous, it goes beyond just saying I don't agree with that, the way that Colin Kaepernick was protesting. And of course, what we've seen as of late with all of the condemnation of Black Lives Matter and taking to the streets and that kind of thing, and not just the riots, but just the idea of people protesting. People have condemned that. Of course, when a football team stands arm in arm and says we're going to take a moment to demonstrate unity in promoting social justice, you still got white people booing. So even in the Colin Kaepernick situation, she demonstrated her roots, I guess. And part of those are the racially biased roots that even a woman who claims to be a champion of civil rights would she defaults back to saying, no, it's dumb for a black man to take a knee during the national anthem. And again, to compare it to flag burning, look, she made clear that she doesn't think somebody should be locked up for flag burning or for taking a knee, but it's ridiculous. And so she completely minimized, never even addressed the topic. She never, in the interview, she never said, look, Colin Kaepernick has a valid point. And it's funny, she had no problem basically calling Kaepernick's actions dumb and ridiculous. But in that same interview, she didn't criticize Donald Trump at all as a candidate. So she had no criticism for people in places of privilege, but she had plenty of criticism to somebody who, although enjoyed a career in football up until that point, she had no problem calling that person dumb or his actions dumb, disrespectful, and ridiculous. And, and again, I know there's a whole lot of people who think that Ruth Bader Ginsburg is just, is a superhero, Wonder Woman. But I think if you really did get into her record, the record of the rulings that she had made, I think you're going to find in many, many cases that she just went with the flow, or in some cases made bad rulings in spite of, perhaps her own rhetoric. And I think that is a problem. So I bring this up because I think there's a lot of praise being heaped upon Ruth Bader Ginsburg. And I'm not trying to just speak ill of the dead. That's not the point. The point being here is that there's another problem. And the problem is that if you ignore the bad rulings, and if you only praise her as having always done right by the Supreme Court, then you're validating those bad rulings. Now, the other thing that I will say, and this is my opinion, that has more to do with the right versus left battle over replacing Ruth Bader Ginsburg. Look, when Scalia died, and there were still 10 months left in Obama's administration, and he wanted to nominate Garland as a Supreme Court justice, the Republican-controlled Senate refused. They said, no, we're not going to let a president in an election year make a Supreme Court nomination. So they refused, and the Democrats were appalled by it. And look, it was wrong for the Republicans to block an Obama nomination. It was wrong. And of course, now they're flipping. Now they're saying not with 10 months left, but with only a little over a month, 40 or 50 days before the election, you've got the Republicans saying, oh yeah, we're going to fast track and we're going to whatever nominee Trump wants to put through. Of course they're being inconsistent. But you know what? You know who else is being really inconsistent? The Democrats. Because if what you're saying the Republicans did was wrong during the Obama administration, then if you were consistent, you were saying, yes, it is right that he nominates somebody, even if it is only 45 days left in before the election, or 5 months, 6 months to the inauguration. But what's happened is, and even Barack Obama weighed in on this. He's saying, well, that the fact that the Republicans have flipped shows their hypocrisy. Well, the Democrats have flipped as well, because if you think that Obama should have had the right to nominate somebody in the run up to an election, then you must think that Trump has the right to nominate somebody in the run up to the election. And look, am I crazy about Trump putting another person on the Supreme Court? No, because these guys make rulings that affect us. Obviously, Ruth Bader Ginsburg made a terrible ruling, and it stands as a precedent that will be referred to for years to come in her City of Sherrill versus Oneida case. But I'll also say that, look, some of Trump's appointees, like Gorsuch, they've ruled for some Native cases. I will say that in all rulings, even the ones that are positive toward, on the face of it, look like they're positive towards Native people, for the most part, they are not. They usually somehow contain us in their laws. The Supreme Court never makes a ruling about our sovereignty. To the extent that they're talking about jurisdiction over a parcel of land, as in Sherrill versus Oneida, it still isn't about asserting sovereignty. It's just about asserting governmental control over a parcel of land, which is different than sovereignty. These courts never rule over real issues of sovereignty, and part of the reason is they probably can't. They're bound by their laws, and they're also bound by trying to impose their laws on us. So none of the Supreme Courts and none of these justices view us as a people who have distinct autonomy from them. They're always trying to impose their will upon us. So it almost doesn't matter if it's right or left. We've had bad rulings by other Supreme Court justices appointed by Democratic presidents. And when I hear Native people saying, "Oh, it's so important that we vote in this election because Supreme Court nominees are determined by the president," well, yeah, they haven't always panned out very well for us anyway. So I bring that up because I don't think that we should get caught up too much. But I think it's fair to point out the hypocrisy of the Republicans, but it also should be pointed out the hypocrisy in the Democrats for believing that because the Republicans got away with doing it to them, that they should be able to get away with doing it. There's no consistency either way. So both sides have flip-flopped, and it's just more evidence of the failure of justice and of equitable governance by the United States. It demonstrates it over and over and over again. There is always a lot of pressure being put on Native people to participate in the U.S. governing systems, the governance. And it's funny because we're seeing a lot more of the flaws being demonstrated. And I say flaws. They're flaws in the whole system, whether it's electoral college, whether it's the distribution of Senate control out of slave era concoctions to give rural states the same amount of representations by the Senate as populated in northern states, or whether it's, again, the distribution of electoral college votes. This stuff becomes more and more evident. I mean, I think people have to understand that the Republicans, I should say, they actually haven't won a popular vote in an election in the last several presidents that they've had. Bush didn't win his initial George W. Bush didn't win the popular vote versus Al Gore, and nor did nor did Donald Trump. It just points to the failure of the system. And I say failure. This is the way it's designed. And so when we get pressure put on us as Native people, especially when the pressure over the Supreme Court nomination issue, I don't think it's a reasonable request that somehow we need to step up in their electoral system, in their governing system. I've said it before. We need to understand the idea of decolonization. But you know what? The broad-based American population, they also need to figure out where their place is in this process. I've heard it said that if is a democracy that doesn't work worth saving, and this isn't about whether Americans are worthy of or whatever, but if the system fails. And we're seeing this failure in the system, whether it's associated with the appointment of Supreme Court nominations, or whether it's, how do you count votes and who gets to determine who the next president's going to be, whether it's the amount of control that a sitting president has over everything from the military to the Justice Department to the appointment of justices. Some of these things demonstrate, especially when you have a system that gives a lot more power to away from the populace and more towards, again, slave era concoctions. It continues to cause injustice. And as we look at things like the call for police reform, that doesn't come in the hands of Republicans, but it also doesn't come in the hands of centrist Democrats. So for us as Native people who are oftentimes get called upon to step up to these elections or to the census or to some of these other United States processes, I say no. And I think everybody has to decide where they fit in to some of these conversations, because we get inundated with propaganda and rhetoric as it is, as these cycles go through. So in this last run up to November 3rd, there's going to be a lot of pressure, and there's going to be a lot of emphasis put on Native candidates and how much we step up. But I think that we have to understand that the system isn't going to work for us. So whether it's Ruth Bader Ginsburg in the city of Sherrill case, or whether it's a lot of the border fights that are happening over a border wall cutting through Native territories, or even the Canadian border cutting through Native territories. These are problems that are always going to pit us against the United States, regardless whether it is a Democrat or Republican in office. So these kinds of problems continue to plague Native people. And until we draw some distinction between us and that process, us and the United States processes, then we will always be a very marginalized player in their system. This is part of the problem. And I think everybody has to understand, Native, non-Native, U.S. citizens, non-U.S. citizens, that what is actually transpiring with the way the United States is functioning, it's functioning as it was designed to, not to accommodate the marginalized, but to accommodate the aristocracy, to accommodate, in many ways, white supremacy. And you see it whether it's in a Ruth Bader Ginsburg ruling or whether it's in the rhetoric of Donald Trump. So it doesn't matter how far on the left somebody thinks the system is skewed, or how far on the right it's skewed. In the end, as I've said it many times before, racism isn't a right thing; it's a white thing. And for those of us who are marginalized by white supremacy and by Eurocolonialism, we have to be able to assert ourselves in a manner that raises the question, that doesn't try to use the system. We can't use the tools of our oppressors to stop oppression. And I think that's just something we all have to come to grips with. So, hey, look, I want to remind people, if you have not subscribed to our podcasts, which you can find by searching Let's Talk Native with John Kane podcast, you may be missing some content. And if you haven't subscribed to our YouTube channel, where you can find Legally Invalid, a great video that I did that kind of lays some of this stuff out on the City of Sherrill versus Oneida case and Ruth Bader Ginsburg's ruling. You'll miss things like that. So by all means, subscribe to our Let's Talk Native TV YouTube channel and catch all of that content as well. And I also want to remind people that we are on Patreon. So if you go to patreon.com/Let's Talk Native, you can support the show by becoming one of our supporters on Patreon. Thanks for listening. Yahweh.